Session of the Tribunal for Consumer Claim Malaysia is now in session. Case number TCCM 2026-0417. Adam Henry versus Indah Mobile Store. I am the tribunal officer proceeding over this claim. As this is a tribunal hearing, I remind both parties that legal representation is not permitted under Section 108 of the Consumer Protection Act 1919. You will each present your own case. Mr. Henry, you may introduce yourself and your companion.
Thank you, Tribunal Officer. My name is Adam Henry. I'm the claimant in this matter. This is my friend Ben, who accompanied me when I purchased the phone and is here to support me today.
Note, for the respondent,
Good morning. I am Ahmad bin Ramli, sales representative of Indah Mobile Store, appearing on behalf of the trader.
thank you. Mr. Henry, please state the nature of your claim.
On 9 July 2026 at around 11 a.m., I went to Indah Mobile Store at Alam Mesra, Kota Kinabalu, and purchased an iPhone 15 for 4,800. Mr. Ramli, the sales representative, told me clearly that the unit was brand new, sealed and unused. I paid based on that representation. About 2 weeks later, I checked the phone's warranty status on Apple's own website out of curiosity, and I discovered the device had already been activated approximately 6 months before I bought it. I was so shocked, so I brought it to an Apple authorized service center, and the technician there confirmed the unit had previously been repaired. This phone was refurbished, not brand new. I went back to the phone and asked for a replacement with a genuinely new unit or a full refund. Mr. Ramli refused both and said the phone works fine, so there was no problem. That's why I'm here today.
Thank you, Mr. Henry. Ben, do you wish to add anything as a witness to the purchase?
Yes, tribunal officer. I was there when Adam brought the phone. I heard Mr. Ramley say, words for words, that the phone was 100% brand new, still sealed. That is why Adam agreed to pay 4,800 without hesitation.
Mr. Ramli, how does the trader respond to this claim?
Tribunal officer, our position is that the phone is fully functional. It powers on, the battery health is over 90%, and there are no physical defects. We believe Mr. Henry is not entitled to a refund simply because of an activation date on Apple system, which could be due to an internal transfer between our suppliers before the unit reached our shelf.
Did your store represent the device as brand new at the point of sale?
Yes, that is how it was listed and how my colleague sold it. But we did not know and still do not accept that it was refurbished. We only accept that it was possibly opened for quality checking.
Do you dispute the finding of the Apple Authorized Service Center that the unit had previously been repaired?
We have not seen the report ourselves, but we maintain that the phone works well and functionality is what matters to the customers.
The tribunal will now hear from the witness. Please state your role.
I am a technician at an Apple Authorized Service Center. Mr. Henry brought this device to us on 25th of July 2026. Using Apple's internal diagnostic tools, we confirmed two things. First, that the device's activation date was approximately 6 months prior to Mr. Henry's stated purchase date. And second, that the unit's service history log showed it had previously undergone a repair consistent with a refurbished or reconditioned unit.
It is possible for a genuinely brand new same unit to show a prior activation and repair record.
No, a brand new unit, still in its original factory seal, would show no activation history and no repair record. What we found is inconsistent with the device being sold as new.
Tribunal officer, may I ask the witness a question?
You may.
Is it possible that the activation was done by the manufacturer or distributor for testing purposes and not because it was resold to another customer?
That is theoretically possible, but it would not explain the documented prior repair. A repair record specifically indicates that the unit was previously serviced after being in use. That is not consistent with the factory quality check.
Mr. Henry, what remedy are you seeking from this tribunal?
My first preference is a replacement with a generally new iPhone 15 of the same specification. If that is not possible, I'm asking for a full refund of 4,800.
Mr. Ramli, if the tribunal were to find in the consumer favor, would the trader be able to provide a replacement unit?
We will need to check stock, tribunal officer, but we could likely arrange a replacement or process a refund if that is what the tribunal orders.
Having heard both party and the witness, the tribunal find as follows under section 34 of the Consumer Protection Act 1999. Goods supplied by description must correspond with that description. The device was described and sold as brand new, but the independent evidence from Apple on authorized service center, a prior activation date and document repair show this was not the case. This also engaged section 10(1)(b) and F of the Act, which prohibits false or misleading representation as to a product history, use or condition. Liability under this part of the Act does not require proof of intention to deceive. The trader argument that the phone is functionally adequate does not answer the complaint because the claim concerns non-conformity with description, not defective performance. These are two separate matters. The failure here is substantial within the meaning of Section 44 of the Act, entitling the consumer to reject the goods and elect its remedy under Section 46. The tribunal allows the claim. The trader, Indah Mobile Store, is ordered to, at the consumer election within 40 days, either A. replace the device with a genuinely new iPhone 15 of indexed specification, or B. refund the full sum of 4,800. Mr. Henry, this order is to be complied with within 30 days from today. Failure to comply with an award of the tribunal is itself an offence under Section 117 of the Act. This matter is closed.
Tribunal officer, if the shop simply refuses to comply with your order, what happens next?
A good question. If the trader does not comply within the period stated in the words, that non-compliance is itself a separate offence under Section 117 of the Consumer Protection Act 1919, punishable by imprisonment or both upon conviction. The consumer may also take steps to enforce the awards as a judgment of.
Was there any possibility of criminal actions against the shop separately from the claim?
Yes, independently of this civil claim, the Ministry of Domestic Trade and Cost of Living may investigate the trader under Section 9 and 10 of the Act, and potentially under the Trade Description Act 2011. Since selling a refurbished device as brand new may amount to a false trade description. That is a separate regulatory matter from what this tribunal has decided today.
This tribunal is now in session, case number 3 TCCM 2026-0512, Lim Sim Sim and Happy Buy Shopee Shop. As before, no party may be represented by an advocate under Section 108 of the Consumer Protection Act 1999. Mr. Lim, please introduce yourself and your companion.
Thank you, Tribunal Officer. I am Lim Sim Sim, the claimant. This is my friend, Rachel, who was with me when I first opened the parcel.
And for the respondent?
I represent Happy by Shopee Shop, the seller in this transaction.
Tribunal Officer, I ordered a Kidman's KMK065 Digital Smart 65L oven in Sakura Pink from the Happy Buy shop on Shopee. I paid 2,799 ringgit. When the parcel arrived, I recorded an unboxing video, as I always do for expensive items. Instead of the oven I ordered, the box contained a much smaller, lower specification oven of the same brand, worth only around 350 ringgit. I contacted the seller immediately with my video and photos of the parcel and shipping label. They told me that the merchandise had been inspected before shipment and insisted the correct item was sent. I then complained to Shopee directly, but they said this fell outside their buyer protection policy. I am asking for a full refund of 2,799 ringgit.
Okay, Rachel, do you have anything to add?
Yes, I was on a video call with Simsim when she opened the box. I saw with my own eyes that the item inside was clearly a smaller, cheaper oven, not what was shown in the Shopee listing. She recorded everything on her phone right there and then.
Okay, how does the treated respond?
Tribunal Officer, our warehouse team checks every item before it is packed and shipped. Our records show the correct 651 Sakura model was 65L Sakura Pink model was picked for this order. We believe there may have been an error on the consumer side, or possibly a mix-up during delivery that is beyond our control.
You have any packing checklist, weighing slip, or dispatch photograph confirming the exact item that was placed in the particular parcel?
We do not have a photograph of the specific parcel. Tribunal Officer, our process relies on staff confirming the item verbally before sealing the box.
So there is no documentary record specific to Mr. Lim order?
That is correct. We only have our general internal process, not a record tied to the specific parcel.
Okay, the tribunal will now hear from the witness.
I am Miss Lim Neighbor. I was present in person when the parcel was delivered by the courier, and I stayed while she opened it. The shipping label clearly showed her name and address, and the parcel appeared sealed and undamaged. When she opened it, the oven inside was noticeable smaller than the picture on the Shopee listing she had shown me earlier when she was deciding what to buy.
Was the parcel tampered with in any way before it was opened?
No, it looked properly sealed with the original shipping tape. There was no sign of it being opened and sealed.
Tribunal Officer, may I ask the witness something?
Yes, go ahead.
Did you personally see our staff pack the item at the warehouse?
No, of course not. I only saw what arrived at Miss Lim's home, which is what matters to her as the buyer.
Okay, Ms. Lim, what remedy are you seeking?
A full refund of 2,799 ringgit. I no longer trust the seller to send the correct item. So I would prefer a refund over a replacement. And I should not have to pay for return postage since this was their error.
Okay, representative, does Happy Buy Shopee Shop have any objection to processing a refund through the Shopee platform's own payment mechanism pending this tribunal decision?
If the tribunal orders it, we will comply and process it through Shopee's system.
Okay, the tribunals has considered the evidence. Section 34 of the Consumer Protection Act 1999 implies a guarantee that goods correspond with their description. Consistent with Section 15 of the Sale of Goods Act 1957, what was delivered to Ms. Lim was not merely a defective unit of the correct oven. It was an entirely different lower value model. This is a clear failure of correspondence with the description. The tractor defense rests on a general assertion that items are checked before shipment but no packing record, waiting, slip or dispatch photograph specific to this order has been produced. Against this, the consumer has produced a contemporaneous unboxing video, photograph and independent witness testimony. On the balance of probabilities, the tribunal accept the consumer accounts. This is a substantial failure within the meaning of Section 44 of the Act, entitling the consumer to reject the goods entirely under Section 45. The tribunal allows the claim the traitor Happy Buy Shopee Shop is ordered to refund the full sum of 2,799 ringgit to Ms. Lim Sim Sim within 30 days to be facilitated through the Shopee platform payment or escrow mechanism where available, with the traitor to bear the cost of returning the wrongly delivered item. This matter is closed.
Tribunal officer, since Shopee is only the platform and the actual seller, can the tribunal make any order against Shopee itself?
This is a fair question. Under Consumer Protection Electronic Trade Transaction Regulation 2024, an online marketplace operator has obligations relating to disclosure and fair dealing, but it does not automatically bear the same liability as the seller under Part 5 of the Act. However, where a platform operates a buyer protection scheme, the tribunal may still direct that a refund order against the seller be processed through the platform own mechanism, as I have done today, even though the order for payment itself is made against the seller.
What if the consumer had not recorded an unboxing video? Would she still have a case?
She may still bring a claim, but without contemporaneous evidence such as a video or photograph, it becomes a matter of one party words against the other, and the tribunal would have to wait whatever other evidence is available. This case illustrates why consumers are strongly encouraged to document parcels, especially for high-value online purchases.
This tribunal is now in session. Case number TCCM 2026-0603, Daniel David versus Autopass. As with all tribunal matters, no advocate representation is permitted under Section 108 of the Consumer Protection Act 1999. Mr. David, please introduce yourself and your company.
Thank you, Tribunal Officer. I am Daniel David, the claimant. This is my sister Farah, who came with me to collect the car on the day this dispute arose.
And as for the respondent,
I am the workshop manager at Autoplus, appearing on behalf of the trader.
Tribunal Officer, I sent my car to Autoplus for a brake repair. Before any work began, they gave me an estimate of 500 and I agreed to the amount for the brake job only. Nobody called me at any point during the repair to say anything else need to be done. When I went to collect my car, I was told the bill was now 2,800 2,800. They had replaced several other parts without asking me first. I refused to pay the extra 2,300 since I never agreed to it. I was only willing to pay original RM 500. The workshop then refused to release my car unless I pay the full amount. That is why I have brought this claim.
Farah, do you wish to add anything?
Yes, tribunal officer. I was with Daniel when we went to collect the car. I heard the counter staff say the bill increased because of additional necessary repairs. But when Daniel asked why nobody called him, they had no answer. They simply insisted the car would not be released until the full payment was made.
How does the charger respond?
Tribunal officer, when our mechanic inspected the brake system, he found the brake pads, disc, and worn suspension components were also in a poor condition, and his professional judgment unsafe to leave unrepaired. We proceeded because we believe it was necessary for road safety, and we intended to inform Mr. David, but our staff say they were unable to reach him.
Okay, do you have any call log, message, or written record showing an attempt to contact Mr. David before the additional work was carried out?
No, we do not have a call log to produce today, tribunal officer.
Okay, so there is no record of Mr. David's consent to the additional 2,300 ringgit in repairs?
No written consent, no. We relied on our professional judgment that the repairs were necessary.
Okay, the tribunal will now hear from the witness.
I'm an independent model mechanic engaged by Mr. David after this dispute arose. To assess whether the additional repairs were necessary, I examined the invoice and the part listed. The brake pad replacement is consistent with a standard brake job and would reasonably fall within the original scope. However, the suspension components replacement, in my professional opinion, was not directly related to the brake complaint and would reasonably have waited for a separate consultation with the customer.
Okay, thank you. In your professional opinion, was it standard workshop practice to carry out and charge for such additional work without first contacting the customer?
No standard practice, and what is expected under the workshop information disclosure regulation is to stop, call the customer, explain the issue and the additional cost, and get approval before proceeding, especially where the additional cost is more than 5 times the original estimate, as happened here.
Tribunal officer, may I ask the witness a question?
Yes, you may.
If the suspension component was genuinely worn, wouldn't it be dangerous to send the car back to the customer without fixing it?
It could be a safety consideration, yes, but the correct process is to inform the customer of the risk and let him decide, or at minimum obtain his consent, not to simply proceed and trust him afterward without any communication.
Okay, Mr. David, what remedy are you seeking?
I'm willing to pay the 500 I originally agreed to. I want my car released immediately upon the payment, and I do not accept the ability for the additional 2,300. I also lost several days without my car because it was hit, and I had to spend money on other transport.
Workshop manager, if the tribunal orders release of the vehicle upon payment of 500 ringgit, is the trader in a position to comply?
Yes, tribunal officer. The vehicle is still at our premises and can be released immediately upon such an order.
The tribunal has considered the submissions and the independent mechanic's evidence under the Contracts Act 1950. The agreement between the parties was limited to a brake repair at 500 ringgit. The trader was not entitled to unilaterally expand the scope and charge for work to finish Mr. David never consented under Section 56 of the Consumer Protection Act 1999, where no price has been agreed for a particular work, the consumer is not liable to pay more than a reasonable price. And here, no price was agreed at all for the additional repairs because no consent was obtained. The Consumer Protection Workshops Information Disclosure Amendment Regulations 2022 further require workshops to keep customers informed before undertaking such work. The trader has produced no record of any attempt to contact Mr. David, while the independent mechanics evidence confirms that at least the suspension work fell outside standard urgent safety practice requiring immediate action without consent. As for retention of the vehicle, the traders lien under Section 170 of the Contract Act 1950 extends only to remuneration properly due for authorized work. Since the additional repairs were not authorized, the lien cannot extend to the disputed 2,300 ringgit, and the trader was not entitled to withhold the vehicle once the agreed 500 ringgit was tendered. The tribunal allows the claim in part. Mr. David is liable only for the agreed sum of 500 ringgit. The trader, Autoplus, is ordered to release the vehicle immediately upon payment of 500 ringgit and to refund any amount that is already paid above that sum. This matter is closed.
Tribunal officer, what should a consumer do if a workshop tries this same thing again? Charge extra without asking first.
The best protection is to put it in writing at the outset. Get a written estimate that clearly states that what work is covered, and tell the workshop explicitly that no additional work should be done without your prior approval, preferably in writing or by message so that there is a clear record. Keep all receipts, invoices, and any communication, as this evidence is exactly what allowed the tribunal to decide today's case.
Could the workshop still take some kind of action against Mr. David for the unpaid 2,300?
Since this tribunal has already determined that Mr. David is not liable for that sum, that finding stands as between these parties. The trader may separately face regulatory scrutiny from the Ministry of Domestic Trade and Cost of Living for its disclosure practices, but that is independent of today's award and does not affect what has been just decided.